You can't sue him. You can't sue his office without the file. And the file never opens. Federal law on this is one sentence. Every person who violates your constitutional rights shall be liable to the person they injured. The Supreme Court has admitted that sentence, on its face, contains no exceptions. So the courts wrote 3. 1976. Imbler versus Pachtman. A prosecutor cannot be sued for how he brings a case against you, not for testimony he knows is false, not for hiding evidence that would clear you. The immunity is absolute. The case ends before anyone examines what he did, which leaves one target. If you can't sue the prosecutor, you sue the office that employed him. 2011. Connick versus Thompson. An office is not responsible for its prosecutor's misconduct unless you prove a pattern of similar violations. One violation, however deliberate, is not a pattern. There is a narrow exception, where the need for training is so obvious that skipping it is itself indifference. A single incident can be enough. The court said hiding evidence does not qualify. Its reasoning was that prosecutors are attorneys, law school, a bar examination, ethics rules, continuing legal education. A district attorney may assume they already know the law. Now hold that beside 1976. When the court granted prosecutors immunity from suit, it told the public not to worry, because a prosecutor answers to the discipline of his professional peers. 35 years later, it excused his office from training him because he belongs to a profession that already trained him. His credentials were the reason he could not be sued. His credentials were the reason no one had to train him. He is protected twice. The man he convicted loses twice. That leaves the pattern. A pattern takes records. In Kentucky, criminal investigation files held by commonwealths and county attorneys remain exempt after the case is closed and after the litigation ends. There is no point at which they open. The proof the courts require you to bring is the proof the statute permits them to keep. John Thompson spent 18 years in prison, 14 on death row. The office conceded it withheld the blood test that cleared him. A jury awarded him $14 million. The Supreme Court reversed it, 5-4. That award ran against the district attorney in his official capacity, payable by the parish. Even if Thompson had won, not one individual would have paid him anything.